Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Today I'm going to take some questions that are on the comment section on the channel. If anyone is joining live, they can ask their questions. I'll try to answer as many as I can. So the first question I see is, I need to sponsor my husband, but I'm a postgraduate UK student, work part-time. Would they consider? So if you're a student on a student visa in the UK, if your course allows a dependent, so usually the way I understand it is if you have 20 hours per week of work allowed, then usually you can sponsor a dependent. But check with your admissions office. If your course allows you to sponsor a dependent, then you can. It doesn't matter whether you're working part time, you are not even working. It depends on the fact that you're a student and your course allows you to bring a dependent. That's important. Check with your admissions team if you're not sure. So you can, the working part time doesn't matter. What are the options? So the next question is, your video would they be denied entry if it's for tourism purpose? What are the options? I don't understand this question. So the question you're asking is, it's on the video. What are my options if my pre-settled status is refused 5 times? I have a question to ask. Would there be denied entry if it's for a tourism purpose? Yeah, if your pre-settled status or any EU status for that matter, settled status, pre-settled status, family permit, anything, that has been refused, you may have difficulty entering the UK. So I have seen this many times in the past. People who have had refusals of any status under the USS, they have been detained, asked several questions, research being done, etc., etc., and almost everyone faces that difficulty. If your EU status is refused, be mindful when you enter as a tourist. You may face difficulties. Okay, there is a live question. Sahir Ali, if course is expired, can we reuse the same course for the same person or can switch to another person? Expired course cannot be used. So whatever the course is defined and defined, you have to apply for a new one. So next one. So the question in the comments is, I have been to the UK 2011 as a student and I hosted 1 year deported expense. Now I want to apply for dependent visa, senior care. Is there any problem? Okay, so deported with my expense. So the question is, the individual lived in the UK as a student, overstayed 1 year, then you're saying that you are deported with your own expense. Yeah, I don't think it's deportation, it may be administrative removal. So you went with your own expense, then from the date you left the UK, you need to wait minimum 12 months to reapply for any visa. So yes, you can apply for a dependent visa, and if your main applicant is a senior care worker, there should not be any problem, provided your relationship is genuine, everything is genuine on the current situation, the work, senior care work, etc., etc. So yes, you can apply after 12 months from the date you left the UK at your own expense. Can a failed student switch? Okay. Next question. My thing is completely different. I propose to terminate. Also, I also cancel my visa now. Staying in PG application. From inside the UK. Yeah. So the question is, student dropped out of the university. University also terminated the student, reported to home office. Home office also cancelled your visa. So I think your curtailment period, cancellation period of 60 days has also ended. Now you are staying in fee waiver application. So you just made a fee waiver application eligible for tier 2 from inside the UK. It depends if you still have section 3C leave. So if you file the fee waiver application within time, that is before the end of that 60-day period of curtailment cancellation, then you have section 3C leave till your fee waiver is decided. Yeah, so if you have filed that in time, not out of time, then yes, you may be able to switch for any other type of visa if you have. So if you want to switch to a tier 2 visa, skilled worker visa, if you have the sponsor, you may be able to switch. But yeah, seek the advice of an immigration advisor. Don't just because take just by the facts of the case. Yeah. So but from the answers questions you are given, if you filed everything in time, you may have section 3C leave. So Sahir, you were clarifying the allocation will exist the same. No, the allocation goes away. For example, I will explain it. So if you have one allocation, you assign it to Mr. X, you put the details of Mr. X, you make the payment of 239 currently. Earlier it was 199. You assign it along with that. You may also pay ISC and all. Once that is assigned, it is used. So that allocation is used, the number one that you had. And if that expires after 3 months from the date of allocation, then you cannot use. The allocation will be gone. It will go back to zero. It will go back to zero. You will need a new allocation. Okay. So next question, Pradeep. I need skilled visa London. Yeah, sorry, we don't provide skilled visas. You need to speak to an employer who is willing to sponsor you. We are just immigration lawyers. Thank you. So next question. I went to the UK 2011 student visa. I was stayed 1 year, 2 months. They caught me and deported me, put me in detention center. Now an expense left, flight ticket. Is that the same person? Yeah, I've answered this. Next question. Arun Kumar, any prospects future for UK as it is battling out huge immigrant crisis? Don't want to comment on any news. If you have any specific question on immigration, yeah, you can ask that. Okay, so you are on a 3 year skilled worker visa. You did not start working prior to the start date on the course, but you did after 4 months later. You've been working consistently for 3 years. Can you renew your visa? So, okay, so Emmanuel's question is you are on a 3 year, you got a 3 year skilled worker visa. You did not start working prior to the start date on the course, but you did after 4 months. So, you started the work after 4 months of the course start date, and you have been continuously working for 3 years. Can you renew your visa? Yes, you should be able to renew your visa. The answer is yes. Thanks for this video. Please, I initially wanted to leave to remain 10-year route 7 months ago. Right now, we are financially fine, but both my spouse and I have now jobs that usually pay about 8,600. Do I wait 26 months pay slip? Applying to switch to 5-year route, or can I apply in January before visa? And I just already 4 months pay slip about 18,600. Yeah, so the question is you have filed your 10-year route application. You got approval 7 months ago on the 10-year route to settlement, and now both you do meet the financial requirement. Your question is, can you apply with 4 months of pay slips and 2 months of pay slips respectively for you and your wife? I don't think that is possible unless you have already earned, unless your salary is very high. You are earning, say, you have 80,000 salary or something, and you already earned 18,600. Only then you can use the lesser 4 months pay slips or 2 months pay slips or 3 months pay slips. But the earned income, earned means the gross earned, you cannot do a proportionate. So for example, if your salary per month is, just taking a random example, 5,000 gross, so 5 fours are 20. So if you have already cost 18,600 mark, you have received the gross amount of 20,000, then you can apply after 4 pay slips. Only then it is possible. But if you're trying to do the proportionate of 6 months and multiply it by 12, you cannot do with 4 months or 2 months pay slip. You have to wait for at least minimum 6 months, from 6 months from the date you started working. Okay, Pradeep Kotian, yeah, how can I apply for sponsorship visa? Yeah, you don't apply for a sponsorship visa, you apply for a job, and the employer issues you a certificate of sponsorship to apply for a work permit. So you need to get a job first, and then the employer will give you the sponsorship. Arun Kumar, next question. What are the work and his or dependent should do without fail to be successful to get ILR after 5 years, point by point? Yeah, care worker. I don't think dependent matters. Dependent can work or not. So my focus would be care worker visa holder. They should be working with the sponsor only and earning the salary that has been proposed, working the correct number of hours that have been promised on the costs. So number of hours work should match the cost. The salary paid should match the costs, and they should continue to work with the sponsor throughout the 5 year period, or if they change sponsor, with the change sponsor. So total 5 year period this should happen. Then they should there should not be any problem with getting ILR. So receive the salary, work with the sponsor, and work for the contracted hours, or or more than that. Okay, Sairali, sir, can you please creative worker visa requirements? It's a PBS or to satisfy immigration officer. Tanuko, just 1 minute. चलो प्लीज अरे मी लाइव है थोड़ा सा मी लाइव है okay, sorry for the disturbance. Yeah, creative worker visa. Yeah, I'm not going to go into the details and explain a visa category over here. It's this live is for straightforward questions and answers. So rather, I would keep it for a consultation or something. You can review it on the requirements on the government website. Uh, I'm working Israel 6 years caregiver also. Israel. Okay, so next question. I haven't completed my study yet. I leave it in between, but my past expiry date was October. Can I switch to a skilled worker visa? Past expiry, gas expiry date. Yeah, so you have not completed your study, your CAS expiry. I think you mean course end date, maybe 10th of October. Can you switch to skilled worker visa? If you did drop out of the course and you did not pay the fees or anything, you may not be able to switch. But if you paid the fees and then failed it, only then you would be able to switch it. So you may need a letter from the college, university stating that the course has been completed, whether successfully or not. But that is important. Just dropping off the course may not help. I don't think that is treated as course completion. Arun Kumar is asking, can a dependent work n number of hours in a week? Yes, dependent can work n number of hours, whatever. There are no restrictions. Next question, two. Can we switch if we travel outside UK during university vacation and apply for tier 2 dependent visa? Sorry, I don't understand your question. So you want to switch, you travel outside the UK during university. You are allowed to travel outside the UK during university vacation, there is no problem. Apply for tier 2 dependent visa. Yeah, you can apply for tier 2 dependent visa outside the UK. There is no restriction on that if you do qualify. So the relationship is genuine and all of that. Can we switch if we travel? Yeah, sorry, I don't understand your question clearly. Can we switch if we travel outside UK during university vacation and apply for tier 2 dependent visa? So yes, if you have traveled outside UK on a university vacation and you want to apply from outside UK for a tier 2 dependent visa, yes, you can. There should not be any problem. I don't see anything. Uh, so, so this question was asked by me. Now I got my visa 30 December for everyone who is looking for switch to work visa from PGDP. It's possible, and my work category is restaurant. Okay, yeah, so this is some success story someone has posted. They seen a previous live or some any of my videos. So failed one module and received PG diploma. Can I switch to skilled worker visa? So I think that was my video or short something. So Sridhar, yeah, has commented. He has said, "Hi sir, this question was asked by me, and now I got my visa." So I think in that video I did advise you can do it. So and now I got my visa today, 13 December 2023. And for everyone who is looking for switch to work visa from PGDIP, so I think PG diploma, that's what it means. It's possible, and my work category is restaurant. So he's joined a restaurant, maybe a chef or something. So yes, he has maybe failed one module or something, and instead of a degree, he has got a diploma, PG diploma, postgraduate diploma, and he was able to switch successfully. So this is another success story. There are several of them now. I think I have 4 or 5 till now. People have reported. So yes, failed students can switch. And size question: after 2 years PHW switching to 3 years work permit. Yes, yes. PSW switching to 3 years permit will be counted for 5 years to our no, the graduate route is not a route to settlement. It cannot be counted towards a 5 year for ILR. Arun Kumar, does receiving overseas deposits in UK bank accounts might hinder ILR route? No, I don't think so. That is your personal thing. If you want to buy a house or make investments in the UK, you can receive deposits for whatever reason. But yeah, nothing, everything in law. If you are doing that, that's perfectly fine. So, yes. Next question. My wife is on a dependent visa. I have tier 2 healthcare visa for NHS. Can she open her limited company for e-commerce? Yeah, so this is what I always talk about. Dependents have full rights to work in the UK. They can start business, they can work with any employer, they can decide not to work, they can study, they can do anything basically, as good as a British citizen till the time they are a dependent. So the question is of Bilal is, my wife is on a dependent visa. I have tier 2 healthcare visa for NHS. Can she open her limited company for e-commerce business? Yes, your wife will have full rights to work in the UK till the time you have your visa. She can open the limited company for that e-commerce business. David, the agency managing my partner's accommodation do not want to issue the letter from the landlords showing they are okay with me joining and living with her. How do we prove which in this case? So yeah, so this is for the spouse visa accommodation requirement. You need a letter from the agency or the landlord confirming that they are happy. I think you were in a shared accommodation. I don't remember, but yeah, that they are happy for the partner, the wife, to come and live in that accommodation. If they are not issuing that letter, then David, that's just you may have to look for another accommodation and move there, or at least have a contract to start from the date on the spouse visa application for entry clearance. There will be a question, when do you want to arrive in the UK? Let's say I'm filing it today and I say 1st of February. So at least from 1st of February or earlier, that new contract should start. So you can take a contract and move there now only, or the new contract can start from 1st of February. And in that contract or from that landlord, make sure you get the confirmation. Yes. So next is, can a person currently garden leave and take a skilled worker visa travel outside? Will it affect their visa in any way? Their garden leave that is paid in full as well. Being employed as usual with employer till the end of the day. Okay, the question is about garden leave. So this is about the skilled worker visa where you are your employment has ended. So and then the employer puts you on garden leave for whatever other considerations that they have, and till that period you are paid salaries and all. But in practice there are different ways. I know Home Office doesn't require that. We had got a clarification on this. In the past we used to report garden leave to Home Office, because every time change of circumstances happen, technically speaking it should be reported. So we used to always report the garden leave and then report the last date of work also, like end of sponsorship also. But Home Office has come back. We have had clarification recently, I think about in last 6 months, I remember, through our Immigration Lawyers Association, that garden leave need not be reported. So Home Office has told us themselves. So we are not reporting. I'm not sure if your company has reported it, but even if whether reported or not, you should be on the payroll. Your sponsorship does continue. Legally speaking, you should be able to travel and return back. You are still employed with your current sponsor on garden leave, unless your sponsor has done something weird and reported you your end date or something in advance. I don't think sponsors would do that. If they have lawyers and all, definitely lawyers will not do it. So unless your sponsor has reported that your employment has ended and they are no longer sponsoring you, which I think it's highly unlikely, I think you should be able to travel on the garden leave. In normal practice, we don't report like that. We don't report at all now. So, Arun Kumar, if a skilled worker visa is refused, what are the chances of getting a visa as a care worker? Of now, what should be the time gap? Yeah, I don't know what are the reasons of the previous refusal. It depends on that. If it was for genuineness and all, they would look at the new visa application very carefully. It can be maybe you were trying to buy the visa or the job was not genuine. Any reasons, it really depends on the facts of the case. So only then, yeah, it depends on the facts of the first case why the first one was refused. Sahir Ali, time of applying, ILR, how many payslips we need? As of the rules as of today, they may change in future. You need only the latest payslip issued within the last calendar month. Latest payslip, latest bank statement, and a letter from the employer confirming you are still required for the employment in the foreseeable future. These are the three main requirements as of today. Only one payslip is required. So, interviewed for shift, so failed student can switch skilled worker visa. Yes, the question is, can failed student switch to skilled worker visa? Yes, failed student can switch to skilled worker visa. We have had at least 4 or 5 success stories till now. Individuals have reported on our channel that they have done it and they have got it. So yes, the answer is yes now. Yes, family, can we apply for 10-year family route separately or in the same application? 10-year family route, 10-year family, what are the benefits of doing 10-year family route settlement? It doesn't matter whether you are applying on the same application form or you are making separate applications. It's more administrative. I don't care about that. Whether you are putting in 4 different applications for 4 people in the family, or you are just adding it on the same. Every form is different. Home office keeps on changing those things. They say allow you to add dependent. Sometimes they don't allow you to add dependent. It really doesn't matter. If you're submitting it on the same day, then it should be fine. It does not have to go on the same application form per se. If the application is allowing, definitely add dependents together on the same application, where towards the end it says, do you want to add a child or a dependent, something. Some forms allow it, some forms don't. But it doesn't matter. That's irrelevant. It's more administrative. So, at the time of application for ILR, do we need to have a course? No, at the time of ILR, you don't need to have a course, but you still need a confirmation from the employer, from your current sponsor at the time, stating that you are required for the employment for the foreseeable future from that point forward. So, that letter is required from the employer. Okay, next one. Hello, if I want to some advice, if I have some advice, contact you. Please send me the right contact details so I can contact you. Yeah, if you want to book any advice session with us, so we do charge for our consultations, advice, representation, everything. So if you want to contact us, just on YouTube, in the bio or whatever that is, the details of YouTube channel details, you should get the website link. You can fill up the contact form or call someone from office will get back to you. Yeah, so okay, next question live from Araba. What do you think about spouse 38,700 gonna happen? Yeah, okay, so that is it. So some clarification that I have is, people who are already on the spouse visa under the 18,600 rule, I don't think it will affect, because the ministers have given some hint saying that we will try not put it on the individuals who already have it. There will be a lot of litigation, that is for sure. Even we lawyers agree that we individuals who are already in the UK on the normal spouse visa requirement 18,600 as of now, we are very positive they will not be impacted. There will be a lot of litigation. We will just go into the courts and just keep on filing appeals, applications, judicial reviews, and everything, and the government will be inundated with a lot of code work, and it will be a mess. So we are 100% sure it's not going to happen with extensions or anything. But yes, they have said 38,700. I'm not sure how practical that would be. But at this time, they have not published the rules. By the time they publish the rules, yeah, that is by March 20, I think. That's when, March 20 or April, sometime it will start. But yeah, currently, whoever is in the UK, I don't think you should worry about the increase or 1838, that it would be completely unreasonable. It will just go to the courts and the judges will really take this very seriously. So I don't think that is anyways going to happen. So it's only for new individuals who are applying for the first time. Some number will come. 38,700 has been quoted now, but I don't know how practical that is. Let's see when the immigration rules have come in. Yeah, so many times the immigration rules are not drafted exactly as things have been stated before. So yeah, let us see when the rules come into play. I will make videos and I will explain about it anyways. Sahir Ali, which payslip is authentic? As a skilled worker, everyone allowed for 20 hours to work in the same field. Which payslip you need from the main sponsor for 20 hours? You need a payslip from the main sponsor. Home office doesn't care about the extra 20 hours. You may work, you may not work. The main sponsor has to give you the payslip, the bank statement showing the payment entry that you have to show, and also a letter from the main sponsor confirming that you are required for the employment for the foreseeable future at that point. Kumar, what should be the criteria for a dependent to start a business regarding capital plans, etc.? Dependent can start their own business. I cannot advise on how to start a business here. Maybe speak to an accountant and all. They are allowed to start any business. That's the only thing I can say from the immigration rules perspective. Okay. I have a question. I was doing okay, not first came back to India, now planning to get visa. Is there a possibility of reaction? Okay, the question is, so Alina was a student in the UK, dropped the course, came back to the India. Now she is planning to apply for a care visa. Is there any possibility of getting rejection from a skilled worker visa? Because you dropped out of your student visa and left the UK, that reason should not be a reason for a rejection. So that will not affect the skilled worker decision because of my past student visa. So, and you were also asked to leave the UK. So if you were asked to leave the UK, if this was the process, you dropped the course, your college reported you, and then Home Office cancelled, curtailed your visa and gave you 60 days and you left, that should not be an issue. That is a normal process of individuals dropping. Individuals drop for many reasons, unable to pay the course fees, don't like the course, any many reasons. You don't it is not especially proven that you are not in breach of immigration rules if you don't go to the course and then your college stops the course and then reports you and then home office says you have to leave the UK. So I don't think that should affect your future skilled worker application. So Araba, I'm planning with my partner to apply in March. I worry about those immigration changing. Yeah, so I really cannot comment what the changes are going to come because immigration rules have not been drafted. So whenever they come, only then I can comment on it. But yeah, I think that's what the government is saying. They are going to make it 38,700. How practical, what comes in, we will see it in time. A person switch to next question. Sahir. So switch to another sponsor needs approval or NOC from previous sponsor. No, you don't need anything from the previous sponsor. You can go to the new sponsor, make the new application, you get the new visa. Very simple as that. You don't even have to inform your previous company sponsor. Next question. Thank you so much for replying. What failed student can switch? Okay. So you are thinking, yeah. So failed student can switch. You are saying thank you very much for replying me about failed student can switch. Yeah, failed student can switch. And thank you for your question. I asked working from June, so 8 months. It's 6 months working with same boss. So my taxable gross pay reached 9,600 this December. Still working in the end of the month. Will be 1,200 taxable gross pay. Question: could I apply for spouse visa? So you started. So the question is about spouse visa financial requirement for 18,600, which is now. I started working from June, so it's 6 months working with same boss. So my taxable gross pay has reached 9,600 this December. Still working in the end of the month will be 11,1200. So 9,600 just to the 9,600 into 2. Yeah, so I think your annual gross is 19,200. So yes, you can apply if you have 6 months of payslips, 6 months of bank statement showing your payment entries, and the letter from your employer. All the formats should be on our website. List of documents for spouse visa. You'll get all the documents over there. And so there are also some videos on YouTube explaining the list of documents for spouse visa. You can just search on the channel spouse visa or list of documents, something like that. A person switched to another sponsor needs approval or NOC. No, my friend is a student, but didn't go to college. Husband is dependent. It's with her in UK. What should go? Yeah, your friend is a student, didn't go to the college. Husband is a dependent with her. What should both do? So I'm not sure what are their visa status is, whether the visa has been cancelled or not. If they are not cancelled, if they have any other visa category, they can move on to that. If they're getting a, I don't think they can get a sponsor because it may be very tricky for them to continue living in the UK legally. Okay, so if they want to regularize their stay, they may get a sponsorship, go back to their home country, apply for a skilled worker visa, and come back again. That may be one of the options. A person is reported to home office on safeguarding issues. If he can apply for another sponsor, Yeah, reporting to home office on safeguarding. Safeguarding is something completely out of immigration rules. Yeah, that's how I understand it. But then, unless any immigration action has been taken, if the visa has been curtailed and all, I don't think that reporting would matter. Just reporting doesn't make any sense. It has to be proven, whatever it is, and a decision has to be made. Reporting is one aspect. A whole process of whatever review and all has to happen, and then whatever decision has to be made. So just reporting does not affect any immigration situation unless a decision has been made on the immigration situation, cancellation or anything like that. They can apply for another sponsor. If their visa is intact, I don't think there should be an issue. But if on the safeguarding issues and all something is there, maybe I don't know any other issues, criminal issues, any other issues that may come into play. But on the immigration side, unless home office has decided anything and inform the individual, that should not affect. They should be able to change the sponsor. That's how I understand things. Next question. You settlement scheme. My husband can apply. My mom, but if European family. Yeah, EU settlement scheme, family permit decision. I think, sir, my husband applied for my mom but refused European family permit. Yeah, so family members, especially mom, dad, and all, home office is looking at very strictly, and they are strictly following the rules. There has to be some level of dependency at the time of Brexit, on the day 31st December 2020, end of transition period, and the dependency has to continue and has to be even today on the date of application. Without that, they will be refusing the applications under the EU settlement scheme for parents, yeah, any family members. Yeah, so how long will it take to get undefined costs? Is priority service available? Undefined costs, yes, there is a priority service available. There are very limited slots, I think 60 slots per day or so. Lawyers have their own way of getting these slots, so maybe speak to an immigration lawyer. We get these slots. Usually, we get a undefined cost. Standard service is 18 weeks. 18 weeks is the decision period. That's how, as of today, that is what it is. And the priority service, you'll get it in 5 working days. Speak to some immigration advisor, and they should be able to apply on your behalf, and they may represent you on that. Or if you can contact us also, and we can also help if time is of essence. Arun Kumar, so my question regarding student visa expiry. Student visa expiry. So I didn't understand which one. Student visa expires in February 2024. Yeah, that student visa expiry doesn't matter, but if the person is not attending the college, it's completely irrelevant. The expiry date is not relevant. The college may have reported them. I don't know what is the situation with the college. Colleges, universities don't keep students active if they don't report, if they don't come to the university. So the person should have been already reported. I am very positive they have their compliance requirements. So if that reporting has been done, yeah, it's technically that may be a problem if they try to switch inside the UK. They won't be able to. Sponsors already sent letter for curtailment for visa with evidence. Is he still can you switch letter for curtailment? So I don't think sponsor can send a letter. Home office has to send a letter. Sponsor can only report to home office through the sponsor management system saying we no longer sponsor this person. That's the only thing. So sponsor no longer sponsoring. There's like a tab that you select, and that's it. That's what the sponsor can do. They cannot do anything. They cannot curtail the visa. So sponsor doesn't curtail a visa. Home office does if they want to. So sponsor just reports I'm no longer sponsoring this person, and then home office whenever they get to it, it can be 3 months, 6 months, 1 year, 2 years. Also, I have seen when they pick it up, they send an email with the curtailment email saying you have 60 days from today to do something about it. Either file for another visa category if you qualify for something, or leave the UK. So yeah, till the time you don't get the curtailment email from home office, you are fine. You still have legal immigration status to live in the UK. So Ayan, if the undefined cost is not coming on time, can I still stay in the UK and let home office know that I am waiting for the undefined one? Yeah, I'm making a skilled worker application and asking the caseworker to hold. It's a difficult one. You cannot do it yourself. Do it through immigration lawyers and all. Home office will not just accept anyone's arguments on this, or else people will just file many applications, and they will be in the home office queue, and that is work for them, and it's pending work that they have to keep on the side. They won't do that. So speak to an immigration lawyer. if that is something you have to time the costs and the application and all, your immigration lawyer should be able to help you. Preferably, it is always better to get the priority service and get the undefined cost quickly. Usually within 5 working days, I have always got it. Many times in 2 3 days, I've got it. Uh, so get that and then file the application. Home office is not going to wait till eternity till the cost decision is made in 18 weeks and all. They may refuse it because if you don't have a cause, that's a validity point. They may declare the application invalid and just throw it back at you, and you are out of Section 3C leave. You don't have any immigration status if it is declared invalid. It's a very tricky one. We also do it very, very carefully if you don't have any other recourse. But yeah, that's not an easy one that you're thinking of. You apply and get the 3C leave and then send a cause whenever you get it after 18 weeks. For the charges and all, please send the emails on the channel. You will have the website link. You can state the facts of what service you want, and someone from office will get back to you. Okay. All our details should be in the channel bio or whatever channel details over there. Okay, next. Okay, again, in fee can I appear IELTS UK by general training of submitting the online skill worker visa application, then during primary document submission book. After 1 month, submit IELTS test report with official passport along with other documents. Yeah, so the question is about you want to submit the skilled worker application, entry clearance outside UK. I think so. Test of submitting. Then during biometric and document submission to 1 month, submit the IELTS test report from. Yes, you should be able to do that because the English language is more on the date of application, date of decision, not date of application. So you can submit your English language test certificate after you can pass the English test also after the application is submitted. So it's not an issue. So for Infi, what you're stating, it is possible. You can file the application, then pass the English test, then attend the biometrics appointment, and at the appointment you can submit the English test certificate. That is possible. Yes. Okay, next live question. How to become an immigration lawyer? What will be the average and only immigration questions over here? Yes, sir. Absolutely right. They sent a letter to revoke the sponsor. Thanks for verification. Okay, fine. Okay, you have asked this. Hello, I am on 2.512. I have two more questions, and if you have any live questions, please do ask them. Maybe within 5 minutes or even in 2 minutes, I may end this live. There are only two questions left on the channel. Uh, Hello, I am 2.5 years spouse visa and I spent 4 months and a half outside. Would it be an issue for the extension of my visa? So the question is about absences from the UK for a spouse visa. There is a detailed video also. Look for absences. I've explained everything. Excess absences, 1 year absences also. But if you are outside for 4 months, it should not affect your ILR. I am very positive. Provided your relationship has existed throughout the 4 year period, either both of you traveled outside or even if you were not together during that 4 month period, if the relationship has been continued, maintained, then no issues with the 4 month absence on a spouse visa. What if sponsor files? Okay, next question, Fatima. What if sponsor files fraudulent case when he along can he get rid of it easily? He got immigration bail detention. Sorry, I don't understand the question clearly. So the question as I read is, what if sponsor files fraudulent case along can he get rid of it easily? He got immigration bail of detention. Sorry, I don't get the question. If you can please clarify. So sponsor has filed a fraudulent case to get rid of the employee who is on skilled worker visa. He got immigration bail of detention. Fraudulent case. Yeah, that fraudulent case has to be. It's not an immigration case. Fraudulent case is it goes in the other courts, whatever criminal courts and all, and whatever is the decision of that may affect the skilled worker status of that individual. He got immigration bail of detention. So the skilled worker, the applicant got immigration bail and he was supposed to be detained. So I don't know, something has happened, but you are alleging that the sponsor has made a fraudulent case. That case will have to be sorted separately basically, but I'm not sure what are the facts of the case. So maybe you can clarify. And can I fill form first for undefined cause and then ask for priority? Fill form. you don't fill a form. You usually go on the SMS and then submit a request for undefined costs. Whoever has the level 1 user access, they should be able to do it. In applicants don't do it. The level 1 user of the sponsor management system has to do it. And then yeah, you can ask, once you make the request, later on you can ask for priority. That is fine. Arun Kumar, my wife entered on 27 November. I'll be entering by 20 December. Which date should be ideal time for both to file ILR? Yeah, you are asking 5 years in the future. So to be on a safer side, obviously if you want to apply together, then it would be the latter, 28 December. But you can also count it from the date of grant of your entry clearance, where the sticker was pasted, the 90-day one. You can also count from there 5 years. So you may have got it on the same day, both of you. So that is the earliest you can count a 5-year block, and the 180 days absences will start from that day forward. So remember that. Student dependent can switch to skilled worker visa. Same question for skilled worker dependent. Student dependent can switch to skilled worker and dependent. Yeah, dependents can switch. There is no restriction on the dependents. The 17 July 2023 changes were brought into place because the Home Office, the government has had issues with students playing around, students saying that I want to study and then coming here and then just changing something else, applying for a skilled worker visa mainly. So that was the main reason that those changes were brought. They didn't have any problem with the dependents, so student dependents can switch to skilled worker visa from inside the UK, but the main student may not be able to if they have not completed the course of study. The main student will have to go outside the UK and make an entry clearance application if they have not completed the course of study. Same question for skilled worker dependent. Same answer for the skilled worker dependent. The skilled worker dependent can switch inside the UK, and the main skilled worker can also switch in the UK and become a dependent. So that is possible. With the skilled worker, there is no issue. Only the main student is the issue. The main student may have to do an entry clearance if they have not completed the course of study. All others in that permutation and combination, student dependent, skilled worker dependent, everyone can switch inside the UK except the main student. Only that person will have to do an entry clearance if they have not completed the course of study. So all my questions completed. No more questions on the channel. Let me refresh. Yeah. So now I'm going to end the live. Thank you very much everyone for joining. Good night.